Good afternoon, everybody. Welcome to our webinar today. My name is Kim Stanger. I'm the chair of Holland and Hartz Health Law Group, and we wanted to give you kind of a quick tour or review of some of the things that have occurred in the compliance front over the past year. Also give you a heads up of some of the things that are coming up. So these are the things that I wanted to talk about today. It's an aggressive schedule. It's actually an abbreviated version of a program that I gave at a national conference. So I'm really just going to highlight a lot of these topics that I'm going to cover today or go through a lot of the details. But my main goal was just to make sure that you're aware of these issues that are out there. So this is only going to be a quick summary. For those of you who actually received and looked at the slides, I think there's about 120 slides. Don't faint. I'm not going to be able to cover all of those slides, but ultimately I decided to leave those in so at least you got it. When it comes time to actually applying the rules, of course, make sure that you crack the books or check the rules to confirm their application in your particular situation. I'm going to be primarily focusing on federal laws today. It's kind of the key issues that I see as the federal issues that we're going to be dealing with right now and in the near future. But there may be other laws that are out there, especially that may apply to your particular provider type. So don't assume that this is everything that's there. And of course, you've got to make sure that you're aware of any additional state law requirements. If you did not receive a copy of the PowerPoints, contact Charles at our office at the link that's there at on the PowerPoints or there on the screen. We're not going to take any questions today, but if you do have questions, we're going through this stuff, feel free to shoot me an email or just use the chat feature and we'll respond. All right, with that disclaimer, let's go ahead and launch into it. First issue I wanted to cover was how we end this pandemic or the issues raised with the post-pandemic compliance. As you know, for the last 3 years or so, we've been dealing with the public health emergency, and we've had relaxed standards, us and other government entities, that allowed us to function more effectively and a bit more efficiently. But those standards will in large part end with the end of the public health emergency. A lot of states have already ended their public health emergency. As far as the federal public health emergency, the current extension is set to expire on January 11th. But the Biden administration has promised that they would give us at least 60 days notice before ending the public health emergency. And since we haven't got that yet, it's likely that the public health emergency will be extended into April 2023, but we just don't know. The bottom line is make sure that you stay on top of that and you're aware of when that public health emergency is going to end, because it's going to affect your compliance with all of those rules and regulations that were waived or relaxed during the public health emergency. The government has given us fair notice. They've told us that we need to start preparing for the public health emergency end. And to that end, they've actually given us some very helpful guidance or a roadmap for helping us end the public health emergency. Website that we've got up there on the screen, that was published on August 18th, and it summarizes the roadmap resources the government has provided to us. In that document, the government warned us that we expect that the healthcare system can begin taking prudent action to prepare to return to normal operations and to wind down those flexibilities that are no longer a feature. To that end, the government has given us a list of all of those items that were waived by CMS, so that you can begin reviewing those list of waivers and evaluate and modifying your practices to the extent that you need to make sure that you come back into compliance. The government has also given a specific fact sheet for different types of providers that summarizes the waivers that are applicable. You can access those at that site that's up there on your screen right there. For example, in the case of hospitals, the fact sheet warns us that at the end of the public health fact sheet will come to an end, including enhanced payment care, telehealth services provided in a patient's home, although that one, I'll talk about that more in a minute. The hospitals without walls, the use of provider-based apartments and other temporary expansion sites, clinical care requirements, physical environment and life safety regulations that were waived or relaxed, the critical access hospital, rural location, bed count, and length of stay requirements, those will go back into place. The Stark waivers for physician arrangements that some of you entered, those waivers will end, and you'll have to make sure that your arrangement is compliant at the end of the public health emergency. That's just a sampling of some of those waivers that you need to make sure that you can. Now, the government has been looking at potentially extending some of those waivers or indefinitely. For example, in the Consolidated Appropriations Act of 2021, Congress permanently expanded the waivers applicable to telebehavioral health services to allow for telebehavioral health services via phone call and the like. In addition, in the Consolidated Appropriations Act of 2022, they gave a 151-day extension on certain telehealth services, not all telehealth services, but certain requirements for Medicare coverage for telehealth services. So once that pandemic ends, you'll have an additional 151 days to make sure that those covered telehealth services are brought into compliance. In September, CMS issued a request for information to identify whether or not there are additional waivers that should be put in place, but to my knowledge, they haven't made any decisions concerning or in response. A lot of you probably wish and hope that the mandatory staff vaccinations, COVID vaccinations, would go away, but that doesn't appear to be the case. In fact, on October 26th, CMS issued updated guidance reaffirming the staff vaccination requirements for all provider types. However, they did reaffirm that, or they did water it down such that it's hard to get a condition level violation. In order to get a condition level violation, you've got to have more than 50% of your staff that are unvaccinated unless exempted, and or your policies and procedures weren't implemented. And that's a pretty high standard. So even though the vaccination requirements are still there, it looks like the government is giving you some leeway. All right, that's the first issue. Let's move on and talk about telehealth. This was a startling statistic for me. In 2019, there were 840,000 telehealth visits. That increased 63-fold in 2 million health visits. So telehealth is dramatically expanded, as you know. There are federal and state initiatives underway to try to retain or further expand telehealth. But in the meantime, you've got to realize that a lot of those relaxed standards that allowed you to do telehealth during the pandemic will end with the public health emergency. When it comes to telehealth, there is no coordinated national standard, right? Each state has its own laws concerning telehealth. So if you are reaching out to provide telehealth within your state, you need to make sure that you're complying with the rules. If you're crossing state lines, you not only have to comply with the rules in your state, but also in the state where the patient is located. The regulations may differ between the two different states. In addition, the regulations may vary even within a single state for different provider types. So you've got to make sure that you're aware of those telehealth rules and any changes in those rules as we are coming towards the end of the public health emergency. Among other things you need to be concerned about when you're talking about telehealth are making sure that you satisfy any licensure requirements. For example, during the public health emergency, a lot of the state licensure requirements were waived so that if you had a license in another state, you could provide telehealth services into the state where the patient was located. But with the end of the public health emergency, either nationwide or in those states, those licensure exceptions have pretty much gone away or will go away. So you better make sure that you still, if you're going to provide telehealth across state lines, that you can still do so and satisfy the licensure requirements. Be aware of DEA and state registration requirements for pharmacy registration and the like. Make sure you comply with the rules for credentialing providers at a particular facility. Make sure you understand the rules for establishing a provider-patient relationship. A lot of the telehealth laws will require the establishment of a patient relationships through some kind of two-way synchronous communication. So make sure that you're aware of whatever requirements those are. Make sure that you're aware of the permissible platforms and the standard of care. In a lot of the telehealth statutes nationwide, they will say something to the effect that, look, just because you're providing telehealth doesn't mean you get a special standard of care. To the contrary, you're held to the same in-person standard of care. So make sure that the telehealth that you are providing satisfies the applicable standard of care. Some states may have particular requirements for informed consent when it comes to telehealth, including specific information you must identify or disclose, including the risks and benefits of telehealth. Make sure you're aware of the remote prescribing rules. A lot of states will limit your ability to do remote prescribing or require some kind of in-person exam as part of the remote prescriptions. There are rules for terminating the patient relationship and avoiding patient abandonment. So at the end of the telehealth visit, that doesn't necessarily mean that you've ended your obligation as a telehealth provider. Beware of scope of practice and supervision. If you're a PA or an NP, you may be able to provide services without physician services supervision in a particular state, but if you cross the state line, the rules may differ. Make sure you're aware of those different rules for scope of practice of medicine. Also beware of the corporate practice of medicine rules. In some states, private corporations can't employ physicians. So if you're going to cross state lines, make sure that you're providing those services through entities that are licensed and able to provide those services in that particular state. There could be other requirements concerning medical records, reimbursement, privacy and security, malpractice standards and procedures. Make sure you've got insurance coverage. Your insurance coverage that protects you in a particular state may not extend to services that are rendered in another state. That's just a quick checklist of all the issues you need to consider when you're evaluating providing telehealth, especially when it comes to providing telehealth. This particular website, the Center for Connected Health Policy, is a great resource if you want to engage in telehealth. It has a good summary of federal and state laws dealing with telehealth and helps you. A couple of other issues. The Ryan Haight Online Pharmacy Consumer Protection Act, federal statute, generally requires providers that they may not prescribe controlled substances via telehealth without first performing an in-person medical evaluation. That was waived or relaxed during the public health emergency so that you did not need that in-person medical evaluation if there was if you could evaluate the patient through the telephone, audio-visual communication, but that will end with the public health emergency. So make sure that your telehealth practices when it comes to prescribing controlled substances are going to comply with this. In addition, as you remember, during the public health emergency, CMS and the OCR waived or relaxed some of the requirements, the security rule. As long as they were not public. But when the public health emergency ends, you may no longer be able to satisfy or use those because they may not satisfy the security standard. Again, make sure that you're monitoring the platforms that you're using to provide those telehealth services. In June, the government issued guidance concerning audio-only telehealth. Basically, they remind you that if you're going to engage in telehealth, even if it's audio only, you still got to comply with the privacy rule. You got to make sure that you've got reasonable safeguards so that you're in a private setting, avoiding other people hearing. You've got to verify the identity of individuals who are participating. If you are going to engage in the transmission of electronic protected health information, then you've got to comply with the security rule. Now, traditionally, the OCR has taken the position that audio only probably doesn't implicate PHI, but that's changed with the change in technology. Now, to the extent that you are using, the internet in order to communicate via a voice over internet protocol, cellular messaging, record and store technology, that type of stuff involving electronic information, then the HIPAA security rules are going to now apply to you. You're going to need to make sure that that platform you use complies with the security rule. If it's still you're using an old traditional landline that's analog only, that will not trigger the security rule, but these other common methods will. So make sure that you're compliant. The government has really focused this year on discrimination in telehealth. It's kind of come to the forefront. In July, the OCR and DOJ issued guidance on non-discrimination in telehealth, both with persons with under the new proposed 1557 rules that we'll get to later. They would actually add a provision expressly prohibiting discrimination in telehealth. In that guidance, they gave some examples of the types of accommodations you might need to implement in your telehealth program in order to avoid the violating the federal discrimination laws. For example, if you're dealing with a person with an intellectual disability, you may need to offer that patient more time for the patient during their visit so that they can negotiate or handle the telehealth. And you may need to provide a support person to assist during the encounter. If you're dealing with a patient who is deaf or hard of hearing, you may need to provide a sign language interpreter during the encounter and use a platform that provides use a platform that provides real-time captioning. If you're dealing with a patient who has a visual impairment, you may need to ensure that any recommendations that are provided through that encounter are screen reader capable. So it's not just the words showing up there, but that your platform is screen reader capable so that they can hear the communication and any guidelines or other written communications that would be provided. Or you should use video with audio descriptions. Now, these are examples. It doesn't say you necessarily must do that, but you ought to look at your telehealth platforms to make sure that you can comply with these discrimination rules. When it comes to limited English proficiency, the guidance suggests that in emails or social media posts about telehealth opportunities that you may provide, you should include a short non-English statement that explains how LE obtain the information in their own language. You should qualified language interpreter if necessary. You should not rely on the patient to bring their own interpreter. You should ensure that the telehealth platform may accommodate an interpreter or a video remote interpreter in order to comply with the rules. So be aware of the discrimination rules in the provision of telehealth. Government actually set up a telehealth website. You can go to this website. Among other things, it talks about improving access to telehealth, including to those with disabilities or limited English. When it comes to telehealth, remember that Medicare relaxed some of its requirements for reimbursement. Those will in large part end with the public health emergency, with the exception of those that were extended by the Consolidated Appropriation Acts. We already mentioned the expanded telehealth. There's also that 151-day extension for other certain telehealth services. That extension would apply to it would allow the original site to be anywhere the patient is located, including the patient's home. That's a change from the typical Medicare rules. It continues with the expanded list of telehealth practitioners. It allows for coverage for audio-only telehealth. It allows for an in-person visit for telemental health. You don't necessarily need the in-person visit anymore. And FQHCs and RHCs may serve as a distant site. After, at least under the current statute as written, after that 151 days runs, then you do return to the pre-COVID rules. There is proposed legislation that would extend those waivers for up to 2 years. But again, we don't have that yet. You'll need to monitor. Be aware that the DOJ is targeting telehealth because there is a lot of fraud, or they think that there was a lot of fraud during the pandemic. So this is an emphasis for the DOJ. So when it comes to telehealth claims, make sure that you monitor things like ensuring you comply with the standard of care, ensure that the services were medically necessary, that beware charging a situation where you're charging both a telehealth visit and a facility fee. You generally can't do both. Beware upcoding or unbundling or other billing and coding problems. Make sure that you satisfy any of the conditions for proper billing according to the payer guidelines, and beware of those changes that will end with the public health emergency. The government also issued a special fraud alert when it comes to telehealth. These primarily deal with telehealth companies, telehealth providers that went out there and set those things up. Most of you aren't involved with those, but you may want to be aware. All right, let's move on and cover the no surprise rules. Those have been in place for a year now. Just a brief recap, there's two portions of those rules. The first portion deals with insured patients who are getting services from an out-of-network provider or facility. That limits the amount that that out-of-network provider or facility can bill, or establishes a process, the IDR process, for determining the amount that they can be. That rule only applies to hospital or freestanding emergency departments or hospital outpatients, not all healthcare providers. In contrast, the separate no surprise billing rule dealing with self-pay or uninsured patients, that applies to all healthcare providers. If you've got any uninsured or self-pay patients, you've got to be concerned about the good faith estimate requirements. That requires you to give the patient a good faith estimate of their charges. If the charges come in substantially in excess of that estimate, that is more than $400, then the patient can initiate that PPDR process to determine the amount that they actually have to pay. In both of those situations, you have to give certain notices to the patient. Let's talk briefly about the enforcement mechanisms. Under the No Surprises Act, the actual congressional statute, it actually puts most of the enforcement responsibility on the states. So the states have the primary enforcement obligations. And to my knowledge, the states really aren't doing a whole lot to enforce that out there. Now, if the states don't enforce it, CMS may come in and impose a $10,000 civil monetary penalty in the corrective action plan. You really haven't seen that going on yet, but it may start coming down now that we've had the no surprise billing rules in place for a year. Of course, the primary method of enforcement is just simply you're going to be limited in the amount that you can recover from either the provider, the balance billing the patient, or in the case of self-pay or uninsured patients, the amount that you can recover from the patient through the PPDR process or the IDR process. So you want to make sure that you're complying with the rules so that you can recover the amounts that you need to or think you're entitled to under the PPDR and the IDR process. In order to comply with those rules, you've got to post your required notices. For example, for all providers and facilities, you've got to post concerning the uninsured or self on your website in a prominent location. It also has to be scheduled, or questions about the items or services occurred. It has to be. If you haven't reviewed or updated that notice, please do so, because the government did modify some of these notices. So you want to make sure that you are using the updated notice. You've also got to post the required notices. If you're in a hospital, ED, freestanding ED, ASC, or an outpatient department with emergency services, that is the notice that limits the amount that out-of-network providers. Sure that you're using the latest version that's been published by the government. You've got to post that on your website and on a prominent sign in your facility. If you're going to seek to balance bill the patient, then you've got to provide a copy of the notice to the patient. When it comes to those insured patients that are, if you're an out-of-network provider and you want to bill for certain insured patients, you need, and that network payer is not going to, you can initiate that IDR process. Importantly, under the original rule, it gave a lot of deference to the qualified payment amount. Of course, the payers didn't like, or the providers didn't like that. They challenged that. And in August, HHS issued its revised final rule to remove the presumption in favor of the qualified payment amount. That was a huge win for the providers. In addition, it requires payers to provide additional information back to the provider if the payer is going to downcode the services that the payer or the provider submitted to them. So make sure in your IDR process that you're aware of the new standards. As clarified in the final rule, now that IDR entity, if you go through that IDR process, that IDR entity may consider the qualified payment amount, but that's not the only factor. Acuity and complexity, the good faith in entering or declining to enter network agreements, market share, teaching status, case mix, and scope of services offered, and other appropriate permissible information. So there is more information you can provide to that IDR entity to get them to side with you as a provider. The IDR entity still may not consider certain information. It's not permitted. You can't submit it, and the IDR entity can't consider it if it is submitted, including things like your usual and customary charges, the amount that would have been billed if the balance billing provisions did not apply, and the payment rates for public payers. You can, if you're an out-of-network provider, the rules generally prohibit you from balance billing the patient set amount, formula of the qualified payment amount that you can cost sharing amount. You can round that and collect more from the patient, balance bill the patient, but you have to jump through a lot of hoops in order to, including providing required notices to the patient, obtaining the patient's consent. And quite frankly, I just don't see that occurring very often. To the extent that you are going to go that way, the government has issued those forms. Again, if you haven't looked or updated those forms recently, make sure you go to the website that's listed there and ensure that you're. When it comes to the uninsured or self-pay patients, you've got to make sure that you notify all of those patients when they come in. You ask them whether they're uninsured or self-pay. You've got to notify them of their right to receive the good faith estimate, and then you've got to give them a good faith estimate if the person even asks about costs. They ask about the cost of service, that's deemed by the government to be a request for a good faith estimate. So you'd have to give them a good faith estimate. You've also got to provide the good faith estimate if the patient requests one, or if the person schedules services at least 3 days in advance. One of the big questions that came up when these good faith estimate rules came out was, what about if we don't schedule the services in advance? We're an urgent care center, emergency room, or something like that, where the patient comes in and they get the services quicker than 3 days in advance. In those situations, the subsequent guidance has confirmed you don't need to provide a good faith estimate in those situations unless the patient requests a good faith estimate and you don't schedule it within the three business days. If they do, even if you're in urgent care, if the patient is just shopping around and wanting to know what the cost of the services are and they call you up and ask for a good faith estimate, then you're generally required to provide a good faith estimate, which doesn't seem to make a lot of sense, but there you go. That's the rule. An important issue. As originally written, the good faith estimate rules required you as a convening provider to, once you get that request for the good faith estimate or you schedule it, one day to contact co-providers. So other providers that would be rendering services in conjunction with your services, like anesthesiologists, pathologists, and the like. So it required you to reach out and get their cost so that you could include it in your good faith estimate. The government, HHS, postponed those co-provider rules. They weren't going to enforce that during 2022. It was supposed to take effect during effective January 1st, 2023, but just a couple of days ago, the government did extend that again. So now they've said those co-provider rules will not be enforced pending future rulemaking. So it's indefinitely suspended. That is very good news and will help alleviate some of the very otherwise overburdensome rules. If that good faith estimate comes back in, or the actual bill is substantially in excess of the good faith estimate, then that patient can go ahead and initiate the process. No big updates on that. Still, that you just need to make sure that you go through that process if you want to collect the amount from the patient. The government has published updated resources dealing with the No Surprise Bill site that's up there on the screen. It provides sample forms that are issued by the government. It gives you training materials that have been issued, fact sheets, FAQs, additional technical guidance. You may want to spend going through that just to make sure that you're current on what the current rules are for the NSP. All right, next issue is the hospital price transparency rules. Those have been around since January 1st, 2021. It requires hospitals to publish their standard charges in certain formats. Remember that you need to do that on an annual basis. done those for a year, then you're with the new year, you need to maybe consider updating those standard charges that you have. The government was concerned that hospitals were not publishing those. So effective January 1st of 2022, so last year, government increased the penalties associated with failure to comply with that rule. Over the past year, as of June, the government was doing auditing and had issued 352 warning letters. Of those 352 warning letters, however, it looks like only 2 enforcement actions were actually brought. There were 2 cases. One, the hospital had to pay $1,000. The other one, the hospital had to pay $2,000. Significantly, in both of those cases, the government sent warning letters and a corrective action plan to the hospitals, but it appears that the hospitals just kind of blew it off, or at least never came back into compliance despite the government's efforts to try to get them to comply. So as long as you're willing to work with the government, it looks like the government's willing to give you a little bit of a grace period. Not sure how much longer that will go. So you need to take the price transparency rules seriously and make sure that you are working on doing the updates if they're needed. If you need resources for that price transparency rule, the government has a website out there, including the regulations. It's got FAQs, technical guidance. And recently, the government updated that website to include certain sample formats that might help. All right, next thing we want to cover are the HIPAA patient and confidentiality rules. Remember that there are a lot of rules that kind of intersect when it comes to this protected health information. Not only HIPAA, but you've also got the information blocking rule, 42 CFR Part 2, state laws and regs. Just remember that you've got to comply with the most restrictive rule under HIPAA. HIPAA preempts anything that's less restrictive. To the extent another law is more restrictive, you've got to comply with the more restrictive law. That's defined as the law that gives greatest protection to the information or gives patients their greatest rights to control his or her PHI. The one that we dealt with most, the one that gave us the most concern, was 42 CFR Part 2, those rules governing programs. However, Congress heard our complaints, and as part of the CARES Act in 2020, they actually passed a statute that essentially modified some of the SUD standards to more closely align with HIPAA. Now, that CARES Act actually took effect in March of 2020, but we did not have the implementing regulations. But guess what? As of November 28, 2022, SAMHSA has now published those proposed rules. So those are out there, and those will be coming down the pipe. Those rules are designed to implement the requirements of the CARES Act. Among other things, those new rules governing substance use disorder records and federally assisted substance use disorder programs. It will permit the use and disclosure of Part 2 records based on a single payer consent given once for all future uses and disclosures of treatment payment healthcare operations. So it kind of incorporates the whole concept of treatment payment healthcare operations into the Part 2 world. And as long as you get the patient's consent for use or disclosure for treatment payment healthcare operations, you don't need to get subsequent consents from the patient for those uses or disclosures for treatment payment healthcare operations. That is a huge boon. That makes it a lot easier to avoid the conflict between HIPAA and Part 2. The new rules, or proposed rules, would permit redisclosure of Part 2 records as permitted by HIPAA with certain exceptions. It affirms the patient's rights to obtain an accounting of disclosures and request restrictions on certain disclosures of Part 2 records consistent with HIPAA. It expands the prohibitions on the use and disclosure of Part 2 records in civil, criminal, administrative, and legislative proceedings. It applies the HIPAA breach notification requirements to Part 2 breaches. So if you have a Part 2 breach, that's a violation of HIPAA, and you would have to do the breach reporting for Part 2 breaches just like you would HIPAA breaches. No new news. That's really not all that new, because if you had a Part 2 breach, you had a HIPAA breach under the old law too, but nevertheless, there it is. That's part of the new rule. It will update the HIPAA Notice of Privacy Practices requirements to include information about Part 2 records, and it will apply HIPAA civil and criminal penalties to Part 2 violations. Under the old rule, under old Part 2, you could be hit up with a misdemeanor and fines for a violation of Part 2. the CARES Act threw out those criminal penalties and basically implemented the HIPAA penalties for Part 2 violations. So let's talk briefly about those HIPAA civil penalties. Remember that those are updated on an annual basis. I think the last update that I've seen was from March of 2022. So under the latest update, you can get hit up with for HIPAA violations anywhere from $127,000 or $127 up to $1.9 million per violation, depending upon the type of violation. If you did not know and should not have known of the violation, the penalties are $127 to about $64,000 per violation. If the violation was due to reasonable cause but not willful neglect, about $1,200 to $64,000. Importantly, there is no penalty under those standards as long as you corrected the situation within 30 days. So that is an affirmative defense to HIPAA penalties. On the other hand, if you act with willful neglect, it's a mandatory penalty of at least $13,000 up to $64,000 if you don't correct it within 30 days, but you acted with willful neglect. If you act with willful neglect and you don't correct within 30 days, it's a mandatory penalty of about $64,000 up to about $2 million per violation. Again, mandatory penalties. The key here is you want to make sure that you do not act with willful neglect. If you don't act with willful neglect and you correct it within 30 days, then you can avoid those HIPAA penalties altogether. Otherwise, if you act with willful neglect, ugly penalties can rain down upon your head, and those penalties can add up awfully quickly. Now, under the Trump administration, they had actually capped, the OCR had capped the amount of the annual penalties that they could impose. We haven't really gotten any additional guidance from the Biden administration on whether or not they are going to continue those caps, so just be aware of that. Those are not the only ways of other means of HIPAA enforcement, however. In addition, under the HITECH Act, they actually provided that mechanism or required HHS to promulgate regulations such that persons who complained about those HIPAA violations, individuals who were affected by that, could get a portion of those fines or penalties or settlements that came out of HIPAA violations. We never got the implementing regulations. However, in March of 2022, HHS issued a request for information soliciting input on how that should work. So we can anticipate that before too long, we will get the rules such that patients or others who are affected by privacy breaches will be able to recover a portion of those fines or penalties, which of course creates an incentive for them to pursue HIPAA actions and may increase the number of HIPAA claims that are actually brought against you. So beware of that. Of course, you still have to self-report breaches of unsecured protected health information to both affected individuals, to HHS and media in certain cases. State attorney generals can bring a lawsuit. And I wanted to point out, remember that there are criminal penalties associated with HIPAA violations. This is important because the civil monetary penalties only apply to covered entities and business associates. If you've got employees, for example, who are not covered entities themselves, then they may not be subject to the civil penalties, but they can be subject to the criminal penalties. And it's really that criminal penalties, that threat of criminal penalties, that you can use in order to rein in their compliance. Key when it comes to HIPAA is remembering what you need to do in order to make sure that you're not acting with willful neglect. Because remember, if you don't act with willful neglect and you correct the situation within 30 days, then it's an affirmative defense to HIPAA penalties. Based on the HHS commentary that came out, particularly with the enforcement rule, you have a good chance of avoiding HIPAA civil penalties so long as you have your required policies and safeguards in place, you train your personnel and document your training, you respond immediately to mitigate and correct any violation, and if it's a reportable breach, that you timely report the breaches. That's really important. If you're doing those things, and even though you have a rogue employee that violates HIPAA, you can generally avoid HIPAA penalties, because as long as you've done these things in the commentary that the OCR has issued, that does not, the employee's violation, you're not liable for the employee's willful misconduct. You would not be acting with willful neglect, and therefore you can avoid penalties so long as you've done these things. So With the beginning of the new year, you may want to look at your policies, your processes, to make sure that you've got these things in place to avoid some of the common HIPAA problems you need to be aware of. Most important, by far, the most important thing you need to be concerned about is security rule compliance. Kind of the one-off, the fax to the wrong place, that may be a HIPAA violation, but you submit it to the OCR and you never hear about it again. It's the security rule violations that result in multiple violations and big ticket potential penalties. So you really have to be aware of security rule compliance. We're going to talk a lot about that in just a minute, but also be aware of encryption of your devices. The OCR has taken the position if you have a device that is not encrypted and it is lost or stolen, then that is presumed to be a breach. MD Anderson, a hospital in Texas, got fined $4.3 million because of the loss or theft of their unencrypted devices. But there was a case, the ALJ decision was actually vacated and remanded by the Fifth Circuit. The Fifth Circuit disagreed with the OCR's presumption that the loss or theft of an unencrypted device is presumptively a breach. The OCR, or the Fifth Circuit, disagreed with that and held that the loss or theft of an unencrypted device is not necessarily a breach. That's an important decision for all of you, but just really remember that that applies to the Fifth Circuit, not necessarily other circuits. So be really careful to make sure that your devices containing protected health information are encrypted, because the OCR still takes the position that it's presumptively a breach if you lose those. Also, be aware of the patient's right of access issues. That's really a hot ticket item right now. The OCR still has its ongoing right of access initiative. So far, that's resulted in 41 settlements because of covered entities provide access as appropriate. A few years ago, the OCR issued the guidance concerning individuals' rights under HIPAA to access their health information. If you have not read that, make sure you go back in and read that. That really is required reading for any privacy officer or anybody dealing with HIPAA. It talks about when you must provide access, who you must provide access. It distinguishes the right of access against patient authorizations and the like. In conjunction with that, be aware of the SIOX case. Remember, the SIOX case came out in January of 2020, and it modified the OCR rules for disclosures per the patient. OCR had issued a rule that basically said if a patient asks you to send their records to a third party, then you're obligated to do that. Not only that, but that is treated like a patient. SIOX challenged that, and the district court, the federal district court, agreed and modified that rule. So this is the way that rule works now. Under the rule, as established by the HITECH Act, if a patient comes to you and requests that you send electronic protected health information to a third party, then you are obligated to go ahead and send that information to that third party. You don't need an authorization. You just need the patient to sign something that tells you to send the information and tells you where to send the information. That is part of the patient's right of access, so you've got to respond to those requests within 30 days. But for the SIOX court, that you are not limited in the amount that you can charge the patient for those fees to a reasonable cost-based fee, like if the patient got those records themselves. On the other hand, if the patient requests that you send paper or other versions of the records, not electronic records, then you're not required to send those records to a third party per the patient's request. You can require an authorization. Even under an authorization, you're not required to send them. If the patient requests that they get the records themselves, then of course you are obligated to provide that, but you're not required to provide those records to a third party unless they are electronic protected health records. So just beware of that distinction. In January of 2021, the government did issue proposed HIPAA rules, but we haven't seen anything further about those rules. Those proposed rules would strengthen the individual's right of access by, among other things, allowing the patient to come in and take notes or use a personal device like their phone to actually take photos of the PH. Shortens the time for responding to requests to access to 15 days rather than 30 days. It requires providers to share the information when directed by a patient. So it would modify that SIOX court decision to require you to send those records to another third party. It further limits the charges that you can impose for producing PHI. It also facilitates individual care coordination. It clarifies the ability to make disclosures for imminent threat of harm or serious threat of harm. It would remove the requirement that you obtain the acknowledgement of the patient's notice of privacy practices, and it would modify the content of the notice of privacy practices. But we do not have the final rules yet. Not sure if and when those are coming out, but just the OCR has issued certain guidance in the wake of Dobbs. Obviously, the Biden administration wasn't too happy with the Dobbs decision, and therefore, shortly thereafter, the OCR issued guidance on disclosing information about reproductive rights. In that, they emphasize that HIPAA prohibits disclosures without the patient's. And they identified certain exceptions where HIPAA would allow disclosures to be made, but they emphasized that HIPAA does not require the disclosures. I think a lot of people reading that interpret that to mean that HIPAA prohibited disclosures. That's not what actually the regulations state. Remember that even though HIPAA does not require the disclosures, for example, if a disclosure is required by law, disclosures are for law enforcement purposes, HIPAA may not require those disclosures, but another law might require those disclosures. So just make sure that you're not misled by that OCR guidance. On December 1st, the OCR also issued additional guidance on online tracking technologies. They warned you that if you are using tracking technologies to collect and analyze information about how users interact with your websites or apps, that may implicate the HIPAA security rules. You need to make sure that those are, that the use of those apps is consistent with those privacy and security rules. Generally, they said that covered entities and business associates are not permitted to use tracking technologies in a manner that would result in an impermissible disclosure of PHI to tracking technology vendors or any other violations of the HIPAA rules. That means you generally can only use that for treatment, payment, or healthcare operations or other permissible exceptions unless you get an authorization. In addition, even where you're permitted, you can only use the minimum necessary. You cannot use that information for marketing or the vendor's own research without the patient's authorization, and you must have a BAA with that vendor for permissible uses of PHI. So if you're operating a website, if you're using mobile apps, you may want to go back and look and see how you're tracking that information and ensuring that you're complying with HIPAA with regard to that information. Right, that's the privacy rule stuff. Let's talk about the HIPAA security rule. This is a huge issue. In fact, this may be the biggest compliance concern because of the potential of the regulation, the violation or exposure to cybersecurity breaches and the like. As you know, the HIPAA security rule requires you to covered entities and business associates to perform periodic risk assessments. They don't tell you how often that's being done, but kind of the unspoken suggestion is that it ought to be at least a year and probably ongoing. Now, in June of this year, the government released its updated security risk assessment tool. So if you don't want to hire a consultant to help you come in and do that risk assessment, you can go to the government's website and use that risk assessment tool. The OCR and the Office for National Coordinating Council, they have training videos that are additional available for you to help with your compliance. So in addition to that risk assessment tool, you've got to implement appropriate safeguards, those administrative, physical, and technical safeguards, and you've got to execute those business associate agreements. The whole purpose of the security rule is to ensure that you not only maintain the confidentiality of your information, but you also maintain the integrity and the availability of the information so that you can use that information if and when you need it. Now, part of the HITECH Act amendments that occurred back in 2021, Congress required the Office for Civil Rights to take into consideration an entity's compliance with, quote, recognized security practices, end quote, when considering HIPAA penalties on October 31st, on Halloween of this year, OCR actually posted a video addressing that requirement. So they posted this video addressing those recognized security practices and what are considered to be recognized security practices. They emphasized in that video that compliance with the RSPs is not safe harbor itself, but it is a factor that the OCR considers when determining the penalties. Those RSPs, the OCR identified those as compliance with the NIST framework or your HICCUP technical volumes or certain other recognized security practices. The bottom line here is you should ensure that your IT people watch that video so they're aware of the standards, the recognized security practices standards, and consider implementing those. As part of that video, they provided you with certain resources that will help you implement or identify and implement those reasonable security practices. Again, make sure your IT people are aware of that and that they follow through to hopefully ensure your. When it comes to all things HIPAA and these things, the OCR actually has very helpful listservs, and you can go on to the OCR websites and sign up to get their notices and things like that. Sign up so that you can get that. All right, that brings us to cybersecurity. Cybersecurity, I think, is the biggest issue, compliance issue facing healthcare providers these days. In October 2022, in their Q4 cybersecurity newsletter, the OCR published statistics which indicated that in 2022 compared to 2021, there was a 69% increase in cyber attacks targeting the health. Already knew that the healthcare sector is a huge target, partly because of the ramifications. People know that the bad actors out there, the hackers know that if they can lock up or install ransomware on your devices, then you have strong incentive in order to pay to get that stuff, get that information back, because how can you really function if you don't have that information? The government said that in the healthcare sector, hacking is now the greatest threat to the privacy and security of. Just recently, Oklahoma State University, they got hit with a $870 settlement because of a hacking breach. Those are just the penalties that the OCR imposed for HIPAA violations. Really, when it comes to cybersecurity issues, the OCR penalties are probably the least of your concerns. The more important concerns are simply patient safety. I mean, how can you provide effective care if you can't access your data, including the medical history of a particular patient? How can you function without your data? Or if you're not sure your data is compromised, how do you know? How do you provide services if you don't know whether the data that you've got is appropriate or accurate? How do you continue to function if you can't bill for your services because either you couldn't provide them or you don't have the information, the data necessary to bill, or there's damage to the infrastructure, the cost of responding to and mitigating breaches. The last data I saw was that a significant breach, the average cost was about $4 million. You could also be subject to FTC or state law violations for failure to comply with cybersecurity rules or implement appropriate cybersecurity practices. You could be subject to lawsuits, and if nothing else, the bad press. So separate aside from the regulatory compliance issues, you got to take cybersecurity very seriously just because the practical ramifications, and it's scary. I was talking with an entity a while ago, and these hackers that are engaging in these ransomware programs, I mean, it's a business for them, and it's surprising how professional they are. They've got this whole routine, and they will actually give you references of entities that can come in there and help you certify the threats to you and all of this stuff. They've got it down to a science, and it is quite frankly very alarming. And therefore, it's really important for you to protect against these cybersecurity issues. Now, if that caution wasn't enough for you, in Q1, the then acting director for the OCR, Lisa Pino, sent out a notice to all healthcare providers in which she emphasized the importance of cybersecurity. She stated, among other things, I cannot underscore enough the importance of enterprise wide risk analysis. You should fully understand where all your EPIHI is, and you've got to implement appropriate best practices, offline encrypted backups, conducting regular scans, regular patches and updates, training your employees regarding phishing and other common IT. The Q1 newsletter, the OCR published additional resources to help you combat cybersecurity, including specific guidance on phishing, exploiting known vulnerabilities, weak cybersecurity practices, list of resources, and the like. You can go to that website, and it contains a whole bunch of resources. In Q4, in October 2022, in the OCR responding to cybersecurity incidents. If you haven't read that, you'd also ought to get that and go through it, because it responding to cybersecurity events. Those are the cybersecurity resources on the federal level. Remember that there are also state data privacy laws. Stuff going on right now in developing cybersecurity statutes on the federal and on the state level. The Cybersecurity Incident Reporting Critical Infrastructure Act, the CIRCIA statute, that actually was passed in 2022, but we don't have the regulations. Once those regulations issue, you will be required to report cybersecurity breaches. If you want to learn about state laws that affect privacy or cybersecurity breaches, you can go to that website right there, and it's got a pretty good summary of the other state laws beyond HIPAA. All right, let's talk briefly about the information blocking rule. That applies to actors, which include healthcare providers, as well as developers or offers of certified and health information networks. It generally prohibits you as providers, as well as those other software developers, from information blocking, which is a practice that is likely to interfere with, access, exchange, or use the use of electronic protected health information. Now, the standard for the violation is a little bit different. For you providers, you only violate the information blocking rule if you know that that practice is unreasonable and it's likely to interfere with the access. For developers or health information exchanges, it applies if they know or should know the practice is likely to interfere. Now, the information blocking rule has been around for a couple of years, but nobody's really taken it seriously. At least healthcare providers haven't, because we don't have the penalties yet. We are still waiting for the rule by which the government is going to establish incentives. And so that's probably why you haven't really cared too much about the information blocking rule. We still haven't got the penalties yet. But beware of the obligations. This last October, the scope of the information blocking rule was expanded. Up until October, it only applied to certain data elements. Now it applies to any protected health information, essentially any protected health information, electronic protected health information that would be. Some examples of information blocking include delaying a response to requests for access. If you get somebody who is not blocked or prohibited from accessing that under the law, if they request access and you delay that response, that's information blocking. Charging excessive fees, imposing unreasonable administrative hurdles, imposing unreasonable contract terms affecting access, including provisions in EHR agreements or business associate agreements, or implementing health IT in non-standard ways that increase the burden. Those are just some examples of information blocking. What's not information blocking? Well, if the blocking is required by the law, so if HIPAA or prohibits you from making the disclosure, then that's not information blocking. Or if the blocking action is reasonable under the circumstances, or the blocking action fits within a regulatory exception. The information blocking rule has a number of relatively. In the guidance that came out about the information blocking rule, I wanted to add a couple of things. The guidance makes it clear that you are not affirmatively obligated to establish patient portals or push out information. The information blocking rule just says, look, if you've got that information in electronic format, information blocking. So it doesn't affirmatively require you to push it out, but if you get a request for that information, you've got to be able to make it available. Specifically, they stated that delays or other unnecessary impediments could implicate the information blocking provisions. In practice, this could mean that a patient would be able to access EHI, electronic health information, such as test results, in parallel to the availability of the test results to the ordering clinician. Think about that for a minute. That's basically saying, okay, you're not required to put that information out, but if you do make it available through a patient network, then you've got to make sure that that's available immediately through that patient network. I want to suggest in the guidance that if you have policies or procedures that you're not going to make it available to the period of time to give the provider an opportunity to review, then that could be information blocking. The default would be that you should, if you've got that information in electronic format, you should make that available immediately to the patient. In addition, remember that under the HIPAA rule, you've got 30 days to respond to a patient request to access protected health information. Information blocking rule, you may not have that long. That look at if the information blocking rule requires you to provide that more quickly than that shorter time period under the information blocking rule. So just be aware of those concerns. Again, most of you aren't too concerned about the IBR because we don't have penalties associated for providers yet, but it could be coming down the pipe. The government has posted some helpful resources on this website. You can go there to get more information. Let's talk briefly about the fraud and abuse rules. No huge changes here. Still got to be concerned about the False Claims Act, the Stark, of course. I wanted to point out the Eliminating Kickback and Recovery Act because you guys are well aware of the Civil Monetary Penalties Law, the Anti-Kickback Statute, Stark, those types of things. But a lot of you forgot about the Eliminating Kickback. ECRA came out as part of the opioid epidemic. It is kind of like the Anti-Kickback Statute on steroids. It says that you cannot solicit, receive in return for referring a patient to a laboratory, recovery home, or clinical treatment facility unless you structure the arrangement to fit within a regulatory exception. So in some ways it's narrower because it only applies to these certain types of providers or services. But if and to the extent you're operating in a lab, whether or not it's related to substance use treatment, ECRA is going to apply to you. Now, I want to make that very clear because if any of you are dealing with labs or you operate a lab, you have to be very concerned about ECRA because ECRA is broader than the anti-kickback statute in that the anti-kickback statute only applies to payment for referrals for government healthcare programs, whereas ECRA applies to any payer, including private payers or government programs. In addition, ECRA, unlike the anti-kickback statute, which has a bunch of regulatory safe harbors, there aren't those same safe harbors in ECRA. For example, under ECRA, under the anti-kickback statute, the anti-kickback statute generally doesn't apply to bona fide employment arrangements, so compensation structures with bona fide employees. Under ECRA, there's an exception, but under the ECRA exception for bona fide employees, it prohibits you from paying the employee based on the volume or value of referrals. So to the extent that you operate a lab or have lab services affiliated with your practice or your facility, you need to make sure that your compensation structures, your arrangements with referring providers, with other referral sources, that it is structured to comply with ECRA, not just the anti-kickback statute. The penalties under ECRA, it's $200,000 criminal fine and 10 years in prison. Could also likely result in violations of the anti-kickback statute or the False Claims Act. So just, I wanted to make sure you were aware of the issues. In the interest of time, I'm not going to go through all of the provider or payer concerns that may be out there. Just realize that when Stark was amended in 2021, they did add a bunch of new defenses for Stark that could be very significant. I just wanted to highlight a couple of them. For you who work with hospitals, they redefined referrals so that it does not extend to referrals for services, including inpatient services, if it does not affect the IPPS. So that may actually, if you've got some noncompliance, the things that were otherwise be noncompliant, if it doesn't affect the IPPS rate that the hospital would otherwise get paid, then you may be able to avoid stark penalties in those situations. There is an additional new safe harbor that applies to situations where you pay a physician. It should be less than $5,000 a year, not more than $5,000 a year. That's kind of a catch-all, and it may help you avoid situations where you didn't have a written agreement in place, but you otherwise are paying the physician for a limited amount of money. This can be an important new safe harbor that you could rely on. There are also new interpretations or clarifications confirming that if you don't have a written agreement in place, you can still rely on a group of contemporary documents that existed at the time, even if it isn't a formal arrangement, in order to satisfy the written agreement. Finally, I wanted to point out that under the new regulations, if you do have a situation where you've got a financial relationship with a physician, it was non-compliant during the term of the agreement. Under the new provisions, you've got up to 90 days after termination in order to bring that back into compliance. So if you can correct the situation within that grace period of up to 90 days after the termination, then you can avoid stark penalties. All right, critical access hospitals. For those of you who are affiliated with critical access hospitals, I already had a fairly detailed discussion of this a couple of weeks ago, so I'm not going to go through any details other than just to point out that during the public health emergency, those location requirements were suspended, but in June of this year, they issued a proposed rule. The rule actually addresses the rural emergency hospitals that the new provider type that they came up with, but is that affect access hospitals. They emphasize that access hospitals, if you're not requirements, then you could use your cause status. So make sure that you continue to comply with that and you're not doing anything that would jeopardize your critical access hospital status on that. In addition, under those new proposed rules, it will would impose new conditions of participation for critical access hospitals. Essentially, it incorporates a lot of the patient rights. Those to critical access. Co-location and space sharing arrangements. If you're allowing other providers to use your space, just be aware of the potential ramifications. It could affect your ability to comply with the hospitals. For example, if that space does not comply with the facility standards, that could adversely affect you. Provider-based status rules. If you're not complying, if you're allowing another entity to use that space, but you're not otherwise complying with the provider-based status rules. And of course, there's stark and anti-kickback concerns. The reason I wanted to mention this is that in November of last year, the government issued new co-location guidance. If you're not familiar with that, you ought to pull up that. Actually fixes the previous to that by taking a less draconian, a less regimented approach and more kind of a general approach to co-location guidance. It addresses space, patient rights, infection controls, and the like. But just be aware of that so that if you are allowing others to use your space or you're co-locating other facilities within your hospital space, that you are aware of that co-location guidance and you review it. Hospital credentialing. I wanted to point out here, good news coming out of the Joint Commission a few days ago, the Joint Commission changed its reappointment period. It used to be 2 years. You had to reappoint your practitioners every 2 years. They have now extended that for 3 years, effective immediately. It applies to those facilities that are Joint Commission accredited, including hospitals and CAUSE, ambulatory healthcare. But beware that this is a Joint Commission change, right? You have to still be aware of your own state laws and regulations, which may still require 2 years. I know for those of you who are here in Idaho, I've had communications with DHW. We're trying to figure out whether or not they're going to extend that to a 3-year reappointment process, which would be helpful to hospitals. If you are accredited by other organizations such as DNV, then you'll need to check with those other organizations to see what their requirements. Finally, let's talk briefly about the non-discrimination rules. During the Trump administration, they kind of scaled back. It wasn't as big a deal, but with the Biden administration, the Biden administration is really pushing the discrimination statutes again, including Section 1557 of the ADA. In August, the Biden administration issued a new proposed 1557 rule. Under the new proposed rule, it would expand the 1557, the prior 1557 rules to entities that participated not under the old rules. It was interpreted in such a way that it didn't apply to entities that just participated in Medicare Part B. Under the new proposed rules, it would extend to basically all healthcare providers who receive any kind of federal financial assistance, including Part B. Under the new rules, sex discrimination includes sex stereotyping, sex characteristics, sexual orientation, gender identity, and pregnancy-related conditions, including abortion. As you may recall, the Trump administration had walked that back and said that it didn't extend to those. The Biden administration has come back and said, no, it does extend to that now. Under the new rules, the healthcare provider is required to give primary consideration to the patient's requested accommodation. It prohibits discrimination in telehealth services, like we talked about earlier. Remember, under the original 1557 rules under President Obama, you had to post certain notices and do those taglines. The Trump administration did away with all of those. Under the new proposed rules, you will have to provide notices of non-discrimination and the availability of language assistance. Not necessarily the taglines again, but there will be new notice requirements. You're going to have to require a 1557 coordinator and a grievance process. You're going to have to train staff regarding your 1557 requirements, and it's going to refine the process for claiming conscience and religious objections. We don't have those final rules yet. Not sure when those final rules will come out, but the final rules are quite lengthy. I would fully anticipate that those rules take substantial form as the proposed detail. The OCR has issued some disability resources that are available on its website here. You can take a look at, go to this website. It includes things like sample the OCR has also been issuing additional guidance on gender-related issues. For example, in March, they issued guidance on gender-affirming care, which basically said that restricting an individual's right to receive or limiting health providers' ability to provide gender-affirming care could be a violation of the anti-discrimination laws. In October of 2022, the Northern District of Texas, to the extent it ever was enforceable, is no longer enforceable, at least under the current rules, and as stated on the OCR's website. OCR also, in the wake of Dobbs, issued guidance to pharmacy stating that affirming a pharmacy's obligations to ensure access to comprehensive reproductive. If that pharmacy does not maintain certain reproductive health care services, that may be a violation of the discrimination statutes. For example, pharmacy fails to stock or make available contraceptives, failing to fill prescriptions for drugs which may be used for abortion in addition to other uses, failing to fill prescriptions that may cause abortion or as a side effect, or failing to fill prescriptions to end ectopic pregnancies. Again, this is just guidance that was issued. We don't have formal rulemaking on any of that. Haven't seen any cases come down with that. Right now, for whatever reason, they limited that to pharmacies, not necessarily to other healthcare providers, but just be aware of that to the extent you operate a pharmacy. HHS has put up a website concerning reproductive rights in the wake of Roe v. Wade, or in the wake of Dobbs. Among other things, that website addresses different issues dealing with reproductive rights, including birth control requirements, medication requirements, access to abortion services, and other preventative health. All right, that is a very quick summary of kind of the stuff that I've been seeing out there on compliance, some of the percolating compliance issues. If you want additional resources, you can go to our website. Just a plug here, we have on our website a bunch of free resources that you can access, including recorded webinars on various issues, most of the things we talked about today, client alerts, white papers, sample site, scroll down, and you can access it there through the links. If you would like to sign up to receive free emails concerning our free webinars or client alerts, just shoot me or Charles an email. We'll make sure you get added to the list. If you have any questions about the things we've talked about today, you're not the only one. I also have a lot of questions about some of the stuff that's out there. But to the extent that I can help, feel free to shoot me a quick email or send me a chat, and I will respond as I'm able, respond offline. Otherwise, thank you very much. Sorry we went over a little bit, but there was a lot to cover. I hope this is somewhat helpful. Have a good week, and if we don't talk or speak before, I hope that you guys have a great holiday.